Before we jump into this courtroom exchange, here's the situation. What starts as a seemingly routine DUI investigation quickly turns into a legal chess match over probable cause, witness credibility, and whether police had the right to detain the defendant at all. The defense is about to challenge the entire foundation of the case, arguing that officers relied on assumptions rather than solid evidence. But the prosecution insists there's enough circumstantial proof to move forward. This moment is crucial because if the judge agrees with the defense and suppresses the detention, the prosecution's case could collapse before the jury even hears the evidence. So, pay close attention to the arguments here, because this debate over what officers actually saw, what the witness reported, and what the law requires could determine whether this case even makes it to trial.
Let's roll, nerds.
You know,
Alex.
Excused?
Oh,
Yes.
okay. You know, the beauty about trial, also the most unnerving thing about trial, is you never know what kind of witness you're going to get. You know, when I tried cases before as a, you know, on the other side, there's two things. You never know how a witness is going to testify. Number one. Number two, you never know how juries will react, what's going to make them happy, what's going to piss them off. And it could be the most minute thing that you would never even think of that just really irks them in such a way that goes against you. So that's what I'm trying to tell you is you never know what kind of witness you're going to get. You know, even if you prep your witness, it's a completely different thing when you get on the stand, because if you've never been on the stand, I have before, because I had a defense lawyer put me on it to testify in a rule invocation problem. I was sweating bullets. I was nervous. I was a wreck. So as you can see, when she was testifying, it's tough. It's not an easy thing. So with that in mind, let's go on the record. I'm going on the record.
Now the defense is about to make a motion to suppress the detention, which is a serious challenge in criminal cases. Essentially, they're arguing that the police did not have a lawful reason to stop or detain the defendant in the first place. If the judge agrees, any evidence gathered after that detention, including statements, body cam footage, or sobriety evidence, could potentially be thrown out. Notice what the defense is focusing on: inconsistencies. The 911 caller reportedly didn't identify who was driving, the vehicle allegedly went in a different direction than officers followed, and the officer may have relied on prior encounters with the defendant rather than fresh evidence. So the big question here becomes, did the officers follow the evidence, or did they follow a suspicion about someone they already knew? That distinction could make or break the legality of the stop.
You wanted to say something?
I'd like to move to suppress the detention for it being illegal and just recite what we know so far. The 911 caller from Sonic stated that they did not give any physical description of who was driving, stated that there was a man and a woman in this vehicle, stated that there was that they damaged their mirror by running into the drive-through, and they turned left out of the restaurant. Officers, well, she didn't say it yet, but she went the other direction, and she even, they state that so they ran the license plate, and on a hunch, they went to, here's kind of the full story, that she did have previous encounters with him, and she said on a hunch, when they saw that plate came back to him, they went directly to where they know he lives. And they wrote in the probable cause affidavit, they saw him exiting the vehicle, which is not true. And there's an interview with the state, with Alex, where he talks to both of the officers, and they both say, no, we did not see him exiting the vehicle. So we have that problem of no identification whatsoever. She couldn't identify him in court from the Sonic call. But then they go to his house, and
Into his house?
they go straight to his house. They don't even go the direction the Sonic person said that the vehicle left. They go westbound. The vehicle was reported to have gone eastbound. She drives over to his house because there's history, and he said that they've been to his house before. They mess with him. They mess with people that are over there. That's kind of, they knew him. But she wrote that in the
hearing right now.
No.
she wrote that in the probable cause affidavit too, that she has encountered him before and she knew him to be an intoxicated driver, for what it's worth. She wrote that in the PC affidavit. That's why she went to his house when she got the name. But she said, I never saw anybody behind the wheel. There was only one person in the vehicle, and the reportee said there were two. They were able to, never saw anyone behind the wheel, observed a vehicle. Was there anyone in the vehicle when you approached? She said no. She said it was off. And then asked if he had keys to the vehicle. She said, I can't remember. No identification of him. Oh, and here's the other piece of information that is really important. If there was going to be some other evidence that he was operating or that was the truck, look for the damage on the mirror. They do that.
My only concern
There's
now.
no damage though.
Concern now. Do we have a witness that sees him driving?
This is where the courtroom tension really ramps up. The defense is pointing out what they believe are major gaps in the officer's narrative: no clear identification of the driver, conflicting witness details, and even the possibility that officers relied on prior knowledge of the defendant instead of concrete evidence from the scene. But the prosecution pushes back hard here. Their argument is based on a key legal principle. Police don't always need to see someone physically driving to prove operation of a vehicle. Courts often allow circumstantial evidence, things like admissions from the defendant, witness statements, or observations made by officers, to establish that someone was driving. So, the jury could end up hearing testimony suggesting the officer watched the vehicle arrive and saw the defendant exit. If that testimony is believed, it could completely undermine the defense's suppression argument. So, what do you think so far? Is the defense exposing a flawed investigation, or is this simply normal courtroom strategy trying to create doubt?
I mean, obviously that's a lot to respond to. I'll just take it about the issue that's at hand, right? Wheeling the defendant, okay?
I don't care about all the extraneous crap. I don't care. My only issue now, because really,
I'll let you the judge. We're relying on the basic premise that the law does not require absolutely a person watching the person behind the wheel. They can still be wheeled, legally speaking, sufficiently through other means, both through an admission, their own admission, and then through other circumstantial evidence. We're getting in both the admission of the defendant who admits to
but you
driving.
can't get to the admission.
That's what I'm saying is we've got to lay the groundwork there in order to get the officer, let the officer testify to all of what she saw, all of the things that Tyler's bringing up. Some of them are partial truths, and maybe they're worthy of being impeached on. Maybe not. We're going to let her testify. The jury should be allowed to hear her testify and decide what is credible and what's not. She's going to testify to what she saw, and she's going to make it very clear that there's literally no one else that could have been driving the car. There's just not. Same thing as if a person comes on an accident in the middle of the road.
There's still a hunch. It's a hunch. Sure.
She's going to testify that she watches the car drive up into the driveway. She's going to testify to you that she watches a male get out of the vehicle. She's going to testify that she doesn't lose visual contact with that person. She's going to testify that she watches the brake lights go off. She's going to testify that this woman that was talked about is there. She's on scene. Tyler's aware of this. I know he's aware. He's read the OR. She's sitting on the porch of the house, right? So she's going to, if we give him the chance, she's going to testify to all of this. This will lay the groundwork to get in at least her body cam when she speaks to the defendant, and you can hear from him himself about what he was and wasn't doing. He'll make plenty of statements on that.
You said there could be nobody else possibly driving, and now you're saying there's another woman at the scene.
Already there when the car pulls up, Tyler. She's on the porch.
Not according to the Sonic people, though. She said that there were two people in the car.
I understand that.
Didn't give any physical description. Could not identify him in the courtroom after 7 times asking.
So listen, the Sonic is why the officers begin. I'm not finished. The Sonic is why the officers begin investigating.
They saw him driving.
You can't talk when he's talking. I can only take one.
Tyler,
I'm sorry.
let him finish.
Sonic is why the officers initially investigated the defendant. That's clear, right? There's the 911 call, even though she was unable to state that she recognized the person in the vehicle on the record. She calls 911, she gives a description, she gives the license plate of the vehicle that she saw with the person driving and that ran into the Sonic. Police get the dispatch, they run the license plate, they recognize the person. They go to that person's residence.
And there's the problem.
Why? Why?
They recognize and they assume who that person is. There's two people in the car. They're making an assumption.
She said that there was the witness just said there was a male, an older white male driving.
Your Honor, if I may, the 911 call does not identify who's driving. So she doesn't know who's driving when she gets dispatched. She doesn't know if a man or a woman's driving. If we listen to the 911 call, she just says there was a man and a woman in a vehicle.
And she writes on a hunch.
I don't think it survives a directed verdict. I don't.
So I don't want to waste the court's time, Judge. We're going to get testimony from the officer about all of the circumstances of what she did and didn't see. She's not going to testify that she saw this defendant specifically behind the door.
I don't
She's
think
not
it's
going to.
relevant.
Okay, so then is it the court's position then that based on the testimony and your rulings on the evidence thus far that you wouldn't allow in the remainder of the testimony such as body worn camera? Okay, then I'll follow.
Sorry.
I'll dismiss.
Yes, Your Honor.
All right. That's it.
So a motion to suppress the detention.
Thank you, Your Honor.
What we just watched is a classic courtroom battle over probable cause and the legality of a detention. The defense argued that officers acted on assumptions, claiming the 911 caller never identified the driver, and that police went straight to the defendant's home based on prior encounters rather than clear evidence. Meanwhile, the prosecution insists that circumstantial evidence and the officer's testimony could still prove the defendant was operating the vehicle. In cases like this, the judge must decide whether the evidence is strong enough to allow the jury to hear the full story. If the detention is ruled illegal, key pieces of evidence could be suppressed, potentially weakening the entire case. But now, we want to hear from you. Do you think the officers had enough reason to investigate this driver, or does the defense have a point about assumptions being made? If you found this case as fascinating as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns just like this.